Every day in the USA, people find themselves in court.
This is the people of the state of Michigan versus Lisa Plight, case number 26-00236-FH. And this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on a motion to quash the bindover. I would invite counsel to place your appearances on the record.
Tiffany Burks on behalf of the people.
Good morning to you, staff and sister counsel. I'm Jonathan Jones. I represent Lisa Plight. Thank you for letting us do this remotely.
My pleasure, Mr. Jones. It's much more efficient in my estimation to do these remotely.
Can I file a list of colleagues who don't get it? Maybe you could talk to them for me.
That would be a bridge too far, Mr. Jones. So
yeah, well, in my line of work, you get nothing you don't ask for, right?
No, I understand, and I do express my opinion, in favor of Zoom hearings, being, better for everyone, particularly, purely, a legal motion. Speaking of which, I did note here that I've got an evidentiary hearing coming up in this matter. Does that concern the same? Is this the same issue that we're having?
Ms. Burks, if I overspeak, correct me or reel me in. But I think the people that didn't think that we needed an evidentiary hearing, so I conceded. But yeah, that hearing date and this motion are the same.
Okay, all right, well, and I guess what I'm trying to drive at there is, do I need to decide this on the spot today, or am I premature before I hear some proofs at the evidentiary hearing?
Ms. Burks, I'm going to let you weigh in on that.
Your Honor, I believe that initially we agreed to an evidentiary hearing, not really realizing what the issue was in this case, but I believe it's proper for the court to decide that today in lieu of an evidentiary hearing.
Okay, all right. Well, and fundamentally, as I see it, having read your motion, Mr. Jones, is these are tough cases, and I did read at least excerpts of that prelim transcript. This is fundamentally I think the charge here is an unauthorized or unlawful posting of a message.
Correct.
Under that state statute, and which does, and I deal with that relatively frequently because I apply it in the context also of personal protective orders. There wasn't one of those involved here, but it's the same standard as a message that is posted with the intent to harass someone on the receiving end of the message can violate the statute. Now, I did note, a portion of the briefing was towards the truth of the issue asserted. And my understanding is, in those contexts, that unlike this isn't a civil suit for defamation, truth, even if it, the information posted is true, you can still be in violation of the statute. Is that accurate, Mr. Jones?
I don't see how that can be, because theoretically, as you said, the standard remains that truth is an absolute defense. But my argument includes more than that, Your Honor, because simply I listed the elements and applied the transcript, and it's not there. Sister counsel had basically asked for a remand to give her an opportunity to improve the proofs, I think on a level conceding the point that the standard was not met. And the case cited, I want to add that to this record, that the case cited dealt with a situation where there was a remand on a case where the issue at play was whether or not a juvenile could be sentenced to life in prison without parole. And within the context of that, the other case that came up that I want to address, the other case cited in there is the Miklovich case, which is 134 Northwest 2D 720 or 375 Mich 536. And in that case, in discussing what happened, that case, a motion was filed after an initial bind over for the crime charge, which is manslaughter. And at a second exam, another count was added, making it negligent homicide. And obviously, the argument is that we're not seeking to add charges or come up with a additional theory. The problem here is that the law requires probable cause on every element of the crime, and we don't have it, not because of interpretation of a possibility, but through the questioning and the sworn testimony, as shown with the jury instruction showing what's going on. There simply is not probable cause on every element. I don't think that's in dispute. The case law doesn't say that the people get unlimited cracks at an opportunity to cure defects. That's why we have the hearing. That's why they have an opportunity to put forth any witnesses, and they're given the choice to rest.
Yeah, no, I'm in agreement with you that right there isn't right the proverbial second bite at the apple or a do-over on a prelim. Once it's done, and we go on the record of the prelim. What is that count? I was a little unclear here. The count 7, I did note. Essentially, of course, as with any crime, there has to be the posting has to be with intent. Is that element 7, or is it 7 the one that says free speech is permitted under the Constitution, and you can't cubby that in the context of this electronic communication statute?
I'm not quite sure what you're asking me, but if you're asking me whether or not there's a mechanism where free speech wouldn't apply, I don't see it. And again, I think that the fact that it's listed in there, described the way it is in the elements, coupled with what the magistrate said. She basically acknowledged that, but she sort of kicked it to you and said, in essence, I don't want to deal with it. She didn't say it wasn't true. She just basically said she didn't want to deal with it.
Yeah, she said, and she treated it like, for lack of a better term, like an affirmative defense, such as self-defense, perhaps, where, it is a separate set, not a separate set, but a set of proofs that stand, sort of independent of the state's proofs, where the burden shifts to you to say this is protected. And you're saying that's not really what the constitutionality requirement of the statute is.
That's true. But to answer your question, I just pulled up my filing. The 7th element is that the message A was posted in violation of a restraining order, which it's not.
Not here, right?
B resulted in a credible threat being made. It wasn't. The proofs support that. And then a credible threat, or C, was posted when named complainant was under the age of 18. Again, that's not the case. These gentlemen were both adults. And then, as I said in the next paragraph, probable cause is required in each and every one. And there's no evidence of probable cause on elements 3, 4, 5, 6, and 7. I mean, it just simply is not there.
All right. And Ms. Burks, so even short of the constitutional requirement, we just simply haven't met the statute in the matter.
Well, I would like to note, Your Honor, that 7th element is only for aggravated message posting. And I don't believe that we charged it that way in this case.
Oh, and the 7th element there is the violation of the protective order, that victim is a child, those requirements.
That's correct, Your Honor. Yes. But the people's position in this, Your Honor, is that the court has 2 options when it finds that probable cause was not met. One, it can dismiss the case. However, the other option, and what the people see more often, is that it gets remanded to the district court for further testimony and further evidence.
Sure. Well, and that way I would be in there. I would be, it says quash the information. In reality, what I'm doing is I'm quashing the bindover, which results in that remand scenario.
That is correct, Your Honor.
Well, again, Judge, what I think the proper remedy, as Sister Counsel said, is to dismiss, because again, all you're doing by doing that is basically giving them another bite at the apple. It's not like these things weren't covered or it's newly discovered evidence. The questions were specifically covered by me to create this record to file this motion. theoretically, if you were to do that and they were to go back, they would either have to, in essence, provide alternative testimony, which is completely unfair. So, I mean, to me, if they want to try and, I think it has to be dismissed without prejudice, but even if you were to dismiss it with prejudice, I mean, I think if they wanted to rewrite it in that circumstance, they could. But again, the process is basically, is this enough to go to circuit court? We seem to all be in agreement that it's not. So the remedy should be a dismissal. They shouldn't be rewarded for failure. Not specifically Miss Burke. She didn't conduct the exam. She's doing her job and she's doing it well. But it is what it is. The law is what the law is. The facts get applied. It doesn't seem like there's any dispute here. She's seeking another bite at the apple, which is the card she has to play. But it's not the appropriate remedy here, as we said. You said yourself moments ago.
What about the
Not just, even if you accept her argument that the jury instructions seventh element doesn't really apply, we still have issues on 3, 4, 5, and 6.
Okay, and well, and those are much broader, right? I mean, the seventh does have those specific situations, and I am familiar, right? Because I, of course, get egg stalking cases, and
Right.
and none of those are present here. But this isn't charged up as an egg stalking, and frankly, I wasn't even aware that the unauthorized posting was a felony that would qualify for bind over. I thought, frankly, it usually would be a misdemeanor type scenario. And I'm
I mean,
thinking,
Your Honor, if the people could add, if the court dismisses this case, I mean, the people just turn around and we're going to refile it.
refile, and we're going to be back to square one, and presumably there will be a request for a prelim, and we'll go through that. Same
That's
exact.
correct, Your Honor. So I
same
think
exact
that,
terms.
dismissing it just drags out the process even longer. Whereas a remand is really in the interest of justice here and for the defendant in this case.
Well,
Yeah, no,
I don't disagree with the efficiency argument, but obviously I'm seeking closure. So I guess if you were to do that, I would specifically request that if the remand is there, that, again, I'm going to pose the same questions, expecting the same result, and would impeach accordingly if the answers were to change based on it being remanded and the environment changing. That really doesn't seem to be a just result for my client. I don't see a way around this where we can say, okay, we didn't have enough, so now we'll create something else. I don't see how that could be possibly a just result.
Sure. Well, and I do.
I'm
Well, I
sorry.
appreciate the fact that, the constitutionality argument, I don't think has been fully developed. I certainly would agree with that. And I am uncertain as I sit here today. Of course, I am well aware that, there is tension between this particular statute and free speech. Of course, there's tension between a lot of statutes and legal remedies and the rights provided by the Constitution. I guess the proverbial over your right to throw a punch. Actually, as I've advised many people, it ends a long time before you hit the other person's nose. As soon as you raise that arm back, you're arguably creating a criminal assault offense against them. So, we do restrain conduct, and there is tension between constitutional protections and the operation of some of these statutes. And this one, certainly because it is targeted at specifically electronic speech, is one that frequently runs into that issue. And I think that that's fair to develop. I frankly don't think that truth, necessarily is a defense in a case like this. In fact, I think that, the argument is here, you're harassing me when I place it in the context of perhaps a personal protective order, saying, some information about, my bad, after all, someone who carried on a torrid affair with a woman and took photographs of them in peri delicto, as it were, and then posted them on the internet. Well, it's true. That did happen, and photographs were taken, perhaps with both parties' consent, but that doesn't give you a, long-term right to slap those things up on the internet endlessly. Obviously, other legal protections for that kind of conduct notwithstanding, that's the sort of thing that I do grant these, protective orders for routinely in this electronic context. And so, it is certainly possible to imagine a scenario where even where the conduct, the underlying conduct, there's truth to the statement, it still becomes harassing or molesting to the intended recipient. And really, I think that's the key element here to be examined in these cases is whether or not when the message is posted, is the intention, I need to clear the air here and, state my truth in this context. Where arguably it would be protected speech, or is it, the kind of scenario where I think everyone and their brother, and perhaps inviting in as many words that to happen, should reach out to this individual and tell them, what a scumbag they are for, having engaged in allegedly this past conduct. And in that case, certainly, you could envision a scenario where the statute was violated, even if the underlying statement is arguably true. So, in other words, the Constitution protects speech in general, but it, are restrictions on that speech. Truth is a restriction in that it allows you not to get sued in a civil context for placing something like this, but I don't think it's necessarily an absolute defense to the harassment statute. So,
Even if two things
go-
with that, Judge,
yeah.
even if you were to take that position on element 7, that doesn't change the lack of probable cause on the other 4 I cited. If you look at paragraph 14, I'll start at 16. The exam transcript is void on probable cause on element 4. On page 56, Judge Holt said, fourth,
Yep.
Ms. Jackson Play posted a message with the intent that it would cause conduct that would make Mr. Stewart or Mr. Martin feel terrorized, frightened, intimidated, threatened, the whole kitchen sink. I know, Mr. Jones, that you said there wasn't a threat. The post was not a threat. That's not what I read in the jury instructions to point towards. It could be it was annoyed, harassed, or whatever. And as I said the defendant posted the message with the intent it would cause harm or whatever. Not only is there nothing on the record that establishes her intent to injure intent, Holtz conceded on page 57, looking into the language of the statute, notes the section does not prohibit constitutionally protected speech, which I expect is the entire linchpin. You alluded to the fact, but this isn't a trial. So that's an abuse of discretion. She's basically saying, you're right, but I'm not going to do the right thing and follow the law. That's classically an abuse of discretion. And the other thing is that the reason why the post was made was her frustration and wanting to be taken seriously. That's another issue. The problem is, Your Honor, this is a comprehensive, clear record where I laid out for you, knowing this day was coming, as I laid out for Judge Holtz, these are the things that have to be proven. And there's clear language copied from the transcript from her evaluation and the testimony that indicates 3, 4, 5, and 6 and 7, which I understand what you're saying, but I don't agree with you, were not met. So even if you take 7 out of the equation, you still don't overcome the issue that there's no probable cause on 3, 4, 5, and 6.
Your Honor, the people would disagree with that argument. So that I believe there, and again, I wasn't at the preliminary examination, but I do believe that there was at least probable cause established that that the defendant knew that her posting would cause 2 or more unconsented contacts. She called out people to go up to the school to take action. That was her whole intent, or at least implied intent. I think that's a question for the jury as to whether or not that she intended for people to do that. But she's specifically saying, go up to the school. I need your support on this. She's asking for community support and community action there. In
Sure.
addition, there was testimony that one of the victims in this case did actually feel terrorized, frightened, intimidated, threatened, harassed, or molested. We're talking
I
about,
read the testimony
Yeah.
where he says, well, people were saying, you dirtbag, you shouldn't be raping people, yada, yada, yada. Just like anytime anyone posts anything on the internet, you get these trolls out there who apparently spend the whole day, reviewing what's posted and feel the need to comment on, it could be someone in Nevada, could be someone
Without
in
her
Sweden.
knowing them, that can't unnerve her, Your Honor. That's just simply I love the expression of bridge too far. These people don't know her. These people aren't authorized to speak for her. How can you say, we have a president who claimed that
Well, let's take it out of the
right. Well, we have a president
who
who the country believed didn't incite a riot, yet Miss Plight should be held to a higher standard. No, that's not how this should work.
No, I don't want to, believe me, veer into any element touching on national politics. I got to stick to the facts in front of me. I can barely manage those in my day to day here. Ms. Burks, what's your position on the constitutional? Should Judge Holtz have evaluated that, as an affirmative defense, or is that one that somewhat like a self-defense would get passed on to the circuit court after the probable cause determination at prelim?
Well, Your Honor, I do believe that would be passed on to the circuit court. I mean, Judge Holmes, I don't think that she can determine whether or not the speech is constitutionally protected or not. And I mean, really, so People v. Dingy is a case that deals with similar conduct. And in that case, the court said that it rejected the First Amendment challenges to the statute, stating that posting a message in violation would not constitute protected speech because it's intended to harass the victim. So I think the court hit on that earlier when you stated about posting a picture or, a scenario that happened. Just because it actually happened doesn't mean that then it can later be used, to harass somebody. So whether or not this sexual assault or alleged sexual assault occurred to Miss Plight, that's not the focus here. It's, did she post about this later and then intend to harass someone for that?
And was her posting, on one hand, I need to state my truth and put it on the record somewhere, and that's just why I'm putting it up there? Or is it this targeted thing saying, by the way, this guy works at your school and you should send him 12 million messages regardless of your connection, non-connection to the school, and then that could veer, into the world of harassment and would probably constitute probable cause. And you're saying that the constitutional issue is along the lines of an affirmative defense that would be examined by me, and it can be pretrial. And certainly, there have been self-defense cases where I entertain that. It's routine to entertain that even prior to trial. But you're saying that wouldn't be in front of Judge Holtz to consider at the probable cause stage.
That is correct, Your Honor.
And my position is, as the case law clearly states, probable cause on each element need be established. That's not in.
And the constitutionality of the speech is one of the elements here, is what
correct. And she that's the biggest problem with the people's argument, is she acknowledged she had to deal with it and just didn't.
All right. Well, I'm gonna have to agree with you on that issue, Mr. Jones. Unfortunately, the remedy is not what you want, and that I will quash the Bindover, remand the issue to the district court for further development, particularly on the constitutionality or alleged constitutionality of the protected speech. And if Judge Holtz concludes that is purely an affirmative defense and gets kicked over to me, we may be sitting here again in a month after we do that prelim over again, or parts of it over again, or Judge Holtz who I do know pretty well because we have daughters in the same grade in school, so I run into her at school events quite regularly, and know that fortunately she seems to be a lot brighter than I am. So she might do a better job of analysis.
She says the same thing about you.
Yeah, it's kind of that unholy alliance of judges there, where you happen to know each other in several different contexts.
One more thing before we can conclude. My clients always attends the NASCAR race in Charlotte at the end of the month. I'm seeking permission for her to go. I trust Miss Burks won't have an issue with that. I'm looking to see if she's got NASCAR stuff on her beautiful wall, so decorated, but I can't see that far behind her. Is that okay with Sister Counsel?
Very well. Ms. Burks, any objection to a modification of bond conditions to allow attendance at NASCAR?
No objection.
Thank
All
you.
right. No, and that seems to be totally unrelated to what we're talking about in the case here, that I'd gladly grant that if you would just send me an order, Mr. Jones. And
I will.
With that, I will quash the bind over and remand to the district court for further development at this time. If you would just send an order.
Yeah, I'll email. Your staff is incredible. Wendy, it's nice to finally meet you since we email like we went to college together. Your staff's incredible, Judge. I just want to make sure.
No, thank you for mentioning that. And they're definitely the classiest part of this operation. I'll agree with that. So
nice to
all
meet you as well, Ms. Burks. All right, I'll get that up to you as quickly as I can. And I guess I'll wait for Judge Holtz's staff to send out a notice for it.
Yeah, that's what I think will probably be the next step. And as I said, there's certainly stuff to talk about here. And if it's anything like the protective order cases I work on, sometimes there's a resolution, mutually agreeable type resolution that can be struck as well. I certainly encourage both you and the prosecutor to continue working on that, as I'm sure you probably already discussed. So,
all right, awesome. Stay safe. Everyone have a good weekend. Thanks for the time. Ms. Burks, nice to meet you.
You too.
Thank you.
The judge reviewed the charge against poor Lisa's post and found the state was missing what it needed most. The lower court ignored the right to freely speak. Now Tiffany must prove intent is not so weak. So back to district court, the case will be remanded exactly as the Constitution has commanded, while Jonathan sends Lisa to a NASCAR